So a big topic, just I think in real estate, legal, and investment circles right now, for obvious reasons, probably the biggest of which is rising interest rates. But a popular topic for us here in the West, and in a lot of lawyers that we've talked to throughout the country, has been creative finance, creative financing, what are also called subject to transactions or wrap transactions, where the buyers are looking to buy property subject to the existing loans on the property. Do you guys handle title on creative finance transactions and or subject to transactions?
So we do, but like I've told other people, it depends on how creative you're getting. Now, I fortunately have never had a subject to go bad, but I have had other people's subject tos go bad that wind up calling my office to see if I can bail them out. And as I'm sure you're all aware, depending on exactly how it's put together, sometimes there is no solution, right? I mean, literally, like I said, I don't go to court. I've had to advise clients, you need to call a litigator and, drag the lender to court because, there's really nothing that we can do on our end. You're not the borrower, you're not on the paperwork. They don't want to talk to you and they just keep pointing to TRID guidelines. And well, I mean, you're kind of stuck. So no, I mean, we deal with a fair number of seller financing. Obviously, we deal with a fair number of assignments and double closings, right? But the subject twos, I'm a lot more particular about when I will actually handle that or when I just look at it and say, you know what, I'm really not the right attorney for this particular design.
So what kind of designs do you see that you're comfortable with? I mean,
So
what are
people
you
don't,
looking to see?
yeah. So people don't believe me, but I promise you I've got the emails to prove it. If your servicer or if your lender is like a small community bank, they will actually turn a blind eye if you sell it subject to, right? You just let them know, hey, I've got so and so, they're going to make repairs to the house and then they're
Hmm.
going to sell it. I'm just giving you fair warning because obviously every Fannie Mae and Freddie Mac security deed, deed of trust, mortgage, whatever your jurisdiction calls it, has a due on sale clause, right?
Right.
No ifs, ands, or
Hmm.
buts about it.
Yep.
So when they find out you've sold it, you run the risk of them just starting foreclosure and not talking to anyone. And again, I've had enough people come to me to try and weasel out of that situation to realize that's not a situation that you want to be in if you can help it, or you can if you just fully understand the risk. So number one, if
Right.
if it's a small lender or servicer, if you can get tacit approval, no problem, right? So long as the parties agree, almost anything is possible. The second way that I'm kind of comfortable doing it is either the property goes into an LLC or a trust, and then obviously you set that person up as the trustee or the contact, right? And then that way you've created a little bit of an air gap between the actual owners and basically the payment of the loan. And so I think those two ways sort of offer some protections in a way. I mean, obviously the tacit approval is the best, that you don't get when your client purchases the property subject to. The original seller doesn't like what you're doing to her mother's home, who happens to be across the street from her. She doesn't like the changes you're making. So she calls the bank and says, Mama died and I sold her property. And then all of a sudden, your client is calling you. Obviously, I didn't close that one, but he called me and was like, Drew, what do we do? And I'm like, not much. Will the lender talk to you?